Dear colleagues, good afternoon. My name is Ekaterina Petrenko, and I'm a researcher at the International and Comparative Law Research Center. We are an independent open platform that provides expertise in the fields of public international law, private international law, and international arbitration. I welcome you all to the webinar organized by the Investment Law and Arbitration Lab. This is one of the projects of the center, and this time we will talk about the third-party funding in international arbitration. Before we proceed to the presentation itself, I would like to say a few words about the lab and its objectives. The center established the lab in 2023, and we invite early career scholars and practitioners to analyze and explore proposals of the ISDS reform conducted by the Ancestral Working Group 3. By providing in-depth consideration of these issues, the lab supports the work that the center does as an observer in the Working Group 3. Another objective of the lab is to introduce young specialists to the ISDS reform so they can learn more about the process of international negotiations and investment arbitration. Today's webinar is based on the research paper written in Russian by two participants of the lab, Anton Zakharau and Evgeniia Saveleva. They have prepared this paper under the supervision of the lab's research advisor, Valeria Grebenkova. I encourage you all to ask questions, and after the presentations, there will be a Q&A session. You can send your questions through a button named chat. You can find below the screen. Let me say a few words about the topic of this webinar. The third-party funding is of particular relevance to the states and investors. Existence of a funding arrangement may impact various aspects of the proceedings, their costs, their duration, as well as impartiality and independence of the arbitrators. The Working Group 3 develops a draft provision on the third-party funding, and it would be discussed at the session of the Working Group 3 later this September. The proposals set out broad requirements to the disclosure and in some instances even allow the tribunal to limit the third-party funding. Without going into much details, I would like now to give the floor to Evgeniia and Anton for their presentation and the analysis of the third-party funding. Thank you very much.
Hello, everyone. So I will start today. My name is Ekaterina, already introduced me, is Evgeniia, and with my colleague Anton Zakharau, we prepared this topic and prepared for today's presentation, and I really hope you will like it. So I will start with an outline, and I will start with an outline, Anton. Thank you. So we would discuss the issues of third-party funding in international investment arbitration, issue by issue. So we would discuss what kind of issues are related to third-party funding in arbitration. And I would like to start with introduction. And so international investment arbitration was not originally designed with third-party funding in mind and with this broad popularization. So there was no originally a regulation of this practice. However, over time, the high cost of arbitration proceedings made funding by third parties an attractive solution for ensuring access to justice and managing financial risk. Because even if you have money, maybe you don't want to invest so much money into investment arbitration proceedings. Because of that, tension emerged. Because the issue is that investment arbitration and third-party funding have very different natures. Investment arbitration, international investment arbitration, involves public law and discusses states' responsibility and investor protection. Third-party funding is a private and usually a profit-driven businesses. So this is generally two different natures. This contradiction raised a lot of issues that we will discuss today, and this led to concerns about need for transparency, for regulation of third-party funding, international investment arbitration. And because of that, UNCITRAL working group has explored different approaches. And it's not only UNCITRAL, there were a lot of other works, but UNCITRAL one of the major reform. And we discussed approaches such as banning third-party funding at all. We discussed the approach of limiting it or introducing a regulatory mechanism. And the current consensus points towards regulation primarily through mandatory disclosure. And I would like to make a comment before we start to analyze the draft articles themselves, that we with Anton analyzed the previous redaction of our draft articles, but we would make comments about the differences between the version that we analyzed and the version that was updated today. Not today, but recently. So I will continue with the first issue, which is an issue of conflict of interest and third-party funding. So, as we all know, independence and impartiality of arbitrators are the cornerstone of arbitration. If this is compromised, the legitimacy of the entire process can be at risk. The principle is embedded in both its national arbitration laws, such as those based on the UNCITRAL model law, and international treaties like the New York Convention. Third-party funding generally increases risk of potential conflicts because obviously you have another party walking around the claimant or respondent. Because of that, the arbitrator can have ties with funding entity or the ties with their counsel or their many options. And even while we don't know the cases, we have not found the cases so far that has resulted in an arbitrator being disqualified specifically because of their third-party funding. Interestingly, there are examples in the opposite direction, because, for example, there are cases where arbitrator expressed negative views about third-party funding, calling a funder different unfortunate names, and this led to the disqualification requests. Over this disqualification requests were rejected. So the key point is that existence of third-party funding can influence the independence and impartiality of arbitrators from very different perspectives. And if funding is only revealed during the proceedings, the consequences may be very severe. It can be a challenge to arbitrator, it can be annulment of the award or refusal of enforcement. So early disclosure, which was proposed by the UNCITRAL reform, is therefore a preventive tool and very rational. So what approaches and rules we had previously? Anton, can you please move to the next slide? So before working group started the reform, the approaches varied, but generally followed the general trend of a need for mandatory disclosure. We can see for the IBI guidelines that provided for disclosure of third-party funding. Why they are not mandatory is generally because IBI guidelines are not mandatory, but themselves, but they provided for disclosure. HKC rules, which are not investment rules, but in commercial arbitration rules, provided for mandatory disclosure by a party before the beginning of proceedings. SIAC rules takes a little bit different approach. They allowed for tribunal to request disclosure and its discretion. And ICSID and CTAC rules kind of like combine both approaches. So they asked the party to disclose the third-party funding before the beginning of proceedings. And the tribunal also had the power to request further details. So overall, we kind of feel and see the very clear trend that more and more arbitral rules are moving towards mandatory disclosure, at least of existence of a funding and the identity of a funder. In cases I think the approach is kind of the same. Anton, can you please also move to the next slide? So in cases, approach is kind of the same. So in about 50% of cases that we analyzed, disclosure request was granted. And typically, tribunals require disclosure of the existence of funding itself and the identity of a funder. But for presentation today, I would like to highlight the case IC Power versus Peru. So why this case is interesting for us today. In this case, the claimant voluntarily disclosed the identity and the beneficial owners of the funder. However, the respondent thought that it's not enough and demanded the disclosure of a full ownership structure of a funder. The tribunal refused the request, stated that there were no rules requiring disclosure of such corporate details. The tribunal emphasized that broader disclosure could be justified in specific circumstances, so it should be case-by-case basis. So, for example, if it be a special purpose vehicle and we wouldn't know who is the funder actually and who is the owner of the funder, we would require more fuller disclosure. However, I would like to highlight that the tribunal also noted that the claimant who would need to disclose and that it was the claimant that would need to disclose, and the claimant may not even have access to all the information. So, for example, when you try to disclose, to ask to disclose the information about third-party funder, its beneficial structures, beneficial owners, and go into the history for 1,000 years, maybe claimant is not a person to ask because a claimant may not have this information. So what we have in the draft provision 12 and the reform proposal. Anton, can you please move to the next slide? Thank you very much. So this discussion brings us to the next, to the text of the working group proposed here. So the draft Article 12 introduced a disclosure requirement. The party, as you can see on the slide, the party must disclose the name and address of the funder, beneficial owner, and any person with decision-making authority in relation to arbitration. And disclosure should be made with a statement of claim or immediately if the funding agreement is concluded later. What challenges we can see here? So, as I mentioned, information about beneficial ownership is held by the funder, not by the claimant. So when we try to ask claimants to disclose all this information, we kind of need to think about whether claimant has access to it, because their sanction to this is severe. The sanction to non-disclosure can lead to suspension, termination of proceedings, which could effectively be even construed as a denial of justice. And another point concerns timing. So we proposed that the disclosure should ideally take place with the very first filed document, not only at the stage of a statement of claim, but I would not stay at this point a lot because talk about this a lot, because actually it was fixed in a new version of the draft articles. So another thing that I would like to talk about is a possible influence of a funder, which is the next issue and the next slide, thank you, which is the next issue with the third-party funding. A recurring concern is whether a funder could exercise control over arbitration. And I would like to kind of structure it and discuss it by the type of arguments that defendants usually raise and they were analyzed during the proceedings. So, firstly, respondents sometimes argue that jurisdiction should be extended to the funder. And this is not generally surprising because sometimes jurisdiction in some jurisdictions, jurisdiction of a tribunal can be of a court can be extended to the funder. But due to the nature of investment arbitration, this is very unlikely. And there are a lot of talks about it, how it will be great that if jurisdiction can be extended to the funder, but this is not a talk for today and not for now. So respondents also have occasionally argued that claimants lose their status as investors if they transfer their economic interest to the funder. So, because we transferred the economic interest to the funder, there is no jurisdiction of a tribunal over the claimant. The claimant is not an investor anymore. So, for example, in Rostinvest Co. versus Russia, the claimant had transferred economic interest in shares to another entity, and Russia argued that Rostinvest was no longer a genuine investor because of it. But tribunal rejected this, stating that investor status must be determined strictly under the BAT, which did not say anything about transferring interest, about excluding certain investments. The economic rights had been transferred. So under the BAT, strictly speaking, the investor was still an investor. And a similar conclusion, generally very technical, was reached in COB versus Slovakia. The tribunal ruled the jurisdiction is determined at the time the claim is filed, and subsequent transfers of rights do not affect the jurisdiction. So this is very, we can see this is very technical answers based generally on the current agreements and current BATs, current rules. So another argument raised by respondents is that the claimant is not a real party, and there is no jurisdiction, obviously, because the funder controls the litigation strategy. And this argument was raised and rejected in Quasar de Valores versus Russia, where minority shareholders of UCOS were financed by Minotep. The tribunal found nothing improper in third-party funding and held that it didn't displace the funder, didn't displace the claimant and the true parties. So this kind of cases confirm that tribunals do not treat funder involvement as equivalent to control over the claim. So all of this suggests that while tribunal may recognize the potential risk on funder influence, may even take into consideration and do something with that, they have limited tools to act on them under the current BATs, including under the definition of investment and investor. So, giving these rulings, disclosure requests, which will be linked to jurisdictional objections, kind of like based on these arguments, are often rejected, and I think would be often rejected. Because tribunals consider that since funder involvement doesn't affect jurisdictional admissibility, why we would require disclosure? Because requiring disclosure in this case would serve little purpose and would contradict the principle of procedural economy. So what we can see in the draft provision 12, which is the next slide, we can see that draft provision 12, at least in a previous form, reflects unilateral attempts to address concerns about undue influence. And paragraph 3 allows tribunals to request disclosure of any rights of a funder to control the claim or terminate the agreement. Any agreement between the funder and the claimant's counsel, and any other information. Generally, the list is not limited. However, the draft doesn't specify how this information should be used. And as I mentioned, there is no clear case law and no clear ways on how the involvement of a third-party funder can influence jurisdiction or admissibility. Also, there is no indication of the status of information under paragraph 3. So does it have, for example, information under paragraph C and D have any preference under information which can be requested under paragraph E? Following this uncertainty, for example, other parties of a working group, like the European Union, propose to include more and more information to disclose under the list of paragraph 3. So to make this list really limitless. So therefore, our proposed option is to simplify paragraph 3 and to make it a single catchphrase, like we have in subparagraph E, which would say that any other information deemed necessary by the tribunal can be requested. And this would avoid the problem with the endless lists and preserve flexibility, because as I say, for example, in the case, in the discussed case about their disclosure in IC Power versus Peru, the tribunal generally stated that we, for example, would ask to disclose more if we would see any reasons to disclose more, if we would see that the funder, for example, is a special purpose vehicle, and it would allow for more flexibility. In addition, we think that it would be a good idea, and we propose developing an international code of conduct for funders. Such code could set a baseline standards addressing issues like sources of funding, links to monetary laundering, to money laundering or corruption, which are discussed today very widely, and it would ensure good faith practice. Importantly, I think why it's will be significant because it would shift responsibility and shift the burden of disclosure from the proceedings themselves to the funder. And for example, following such code or accepting such code or using such code could be a requirement for a funder to work with a certain arbitral institution. And I think in our opinion, it will be a good idea to shift the burden of very long and very burdensome disclosure procedure from the process itself and from the claimant to the funder and to the arbitral institution. So the last but not least in the issue in my part of a presentation is the issue of confidentiality. And confidentiality is traditionally one of the key features of arbitration, but it becomes more complex that third-party funding is involved. Despite its complexity, it's totally ignored. Because funders, the issue is that funders are not parties to arbitration proceedings. So any confidentiality obligations that you have in your arbitration proceedings, they do not automatically extend to them. In practice, however, funders will receive sensitive documents. First, they would need to decide whether to fund, so we need to receive documents prior to funding, and during the proceedings, the party would usually submit documents to them. And the issue is that not only funder will receive documents, by funder will ask outside consultants or investors, which would raise risk of uncontrolled disclosure. And today, neither national laws nor most arbitral rules provide clear guidance on how to handle this issue. The exception is, for example, Australian rules of Australian arbitral institution, which require funders to agree to confidentiality, but which remains this kind of like guidelines and rules remains very rare. Case law is also inconclusive. So, for example, in a case Eurogas versus Slovakia, the tribunal stated that funder should have ordinary confidentiality obligations without explaining what ordinary confidentiality obligations actually is. And this is actually very important because jurisdiction to jurisdiction, we have very different rules of what confidentiality means, what you need to disclose, what you cannot disclose, and things like that. They really different, for example, in common law and civil law countries. And UNCITRAL working group has acknowledged this problem, but draft provision has not offered any solution. And we don't think that disclosure alone can solve this issue because we don't know how disclosure can help with confidentiality, but we think that a stronger approach would be a development, as I said, a development of an international code of conduct for funders, which would establish basic obligation to maintain confidentiality. And I think even very basic rules that the information that you share should be confidential, what you should conclude in an agreement according to your rules of your jurisdiction would be a very good guideline, at least for now, because now we don't have such a code at an international level. And I would like to end my part with a comparison of new rules and old version of a draft provision 12, which shows that in the end, the working group, I included on the left is the old version, on the right is the new version, and in bold is the differences between the old and new version. And this is the parts which are related to disclosure obligations. So, and we can see that a working group actually did not follow our recommendation, very unfortunately, and tried to include more information to disclose in the Article 12 and expanded to include more and more details from ownership to remuneration and to even other claims funded against the respondent. The result is that provision keeps growing and it keeps imposing disclosure duties that maybe, I think, at least in my very maybe unknowledgeable opinion, may be excessive or even impossible to comply with. And from a practical perspective, sometimes I think it can be unrealistic to ask for disclosure of some things which are proposed here. So, for example, we can see that under Article 3, subparagraph C, we can see the disclosure of other claims funded by the third funder or its related entities against the respondent. So I'm not really sure that claimant would have such an information. And I'm not really sure that we can be sure that third-party funder would provide to the claimant the full disclosure of such information. And also, I'm not really sure whether it will be fair to apply sanctions if claimants cannot disclose, or it discloses something and after that it seems that the disclosure was not full and, for example, the funder didn't provide all the information needed under the paragraph 12. In the end, this illustrates how the attempt to satisfy all states' concerns in one text risk undermining both clarity and feasibility of application overall. And I would ask my colleague Anton to kindly proceed with his part of the presentation. Thank you.
Dear colleagues, good afternoon. It is my great pleasure to be here today, and I hope you really enjoyed this presentation so far, and I try to do my best to make it as enjoyable as this kind of event can be. Over the next 25 minutes, I will discuss how third-party funding impacts the tribunal's decisions on costs, including, as you may see on the screen, security for costs and cost allocation. First of all, we should focus on, well, it's not a secret to anyone that states can act as award creditors. And this is typically a situation when the arbitral tribunal allocates costs at the end of the proceedings, not in favor of the claimant. And apparently not a secret to anyone that states sometimes struggle to recover costs from claimants. And well, to reduce potential losses, states might in fact apply for security for costs and seek security for costs to not to risk taxpayers' money in endless proceedings against the claimants. Why is third-party funding is important here? Why we're discussing this in this particular context? From our opinion, well, our opinion is that third-party funding is generally felt as a red flag because it may indicate a claimant's inability to pay costs. And another point to mention is that a third-party funder is typically out of the reach, out of the tribunal's reach. So it means that tribunal has no razione persona jurisdiction over the third-party funder. And it is generally felt that the third-party funding affects the ability of the state to recover costs. That's the reason why this topic is discussed in conjunction. Well, let's move on, and the first point to discuss is whether third-party funding in fact triggers security for costs and to what extent. As a part of our research, we've reviewed a lot of positions of the arbitral tribunals to see how the tribunals handled this question over approximately 10 years from now. And our conclusion is that third-party funding alone does not justify granting security for costs. This is the bottom line here, and we understand that there are no publicly available arbitral awards in which the tribunals agreed to grant security for costs just because the claimant or the respondent is relying on the third-party funding. So as you might see on the screen, in Garcia Armas versus Venezuela, the tribunal gave its opinion on how third-party funding can be approached, and the reasons for resorting to third-party funding are in fact vary. And so that's probably something that Evgeniia already mentioned, that third-party funding is not always an indication of bad financial situation. So in some cases, it is apparently something that helps you to manage your financial standing to, that's a simple commercial decision. So that's a bottom line here. So we understand that third-party funding in any event should not trigger security for costs. Another notable case to mention in this particular context is RSM versus St. Lucia. This case is remarkable for a number of reasons. However, we will focus on the assenting reasons given by the arbitrator, Gavin Griffiths, who in fact heavily criticized third-party funders for their, I would say, mercantile endeavors to fund BAT claims. And the most significant part of the assenting opinion of Gavin Griffith is that he suggests, and if we discover that the claim is funded by a third-party funder, then the claimant is supposed to prove that in this particular case, security for cost order should not be made against him. So this is some kind of the rule that shifts a burden of proof onto the claimant who is relying on the third-party funding. Well, as Evgeniia mentioned, in this particular case, Gavin Griffith faced an application for disqualification. However, he managed to survive this application. So that's probably the cost of his opinion in this particular case. We move on, and we understand that in practical situations, we might face something that is more complex than just third-party funding, and sometimes the respondents are able to prove that the claimant is in a bad financial situation. So what happens then if we as a counsel for the state managed to find out that the claimant who is relying on third-party funding is in fact is half bankrupt, or at least he is unable to proceed with the claim itself? Generally accepted approach is that third-party funding and financial difficulties coupled should not result in a security for costs, and you might see the reasoning given by the Eurogas versus Slovakia tribunal. So this is one of the most respected authorities, and we know that in the subsequent cases, the tribunals they cite this particular reasoning very often. Now let's imagine that in this particular situation, when we discovered that the claimant is relying on third-party funding, the factual setting is kind of different, and we understand that the company who's acting as a claimant is bankrupt, and we see that the funder is assuming no responsibility over the costs which might be allocated in favor of the respondent in these proceedings. This is something that happened in a case of Herzog versus Turkmenistan, and you may see the description, the extract from the decision on security for costs on the screen. So in this particular case, Dr. Herzog was acting on behalf of the Union Medex, the company who was bankrupt, and this company was relying on third-party funding, and the funder, La Française, decided not to assume any liability over the costs in case Turkmenistan will be awarded some. This case is equally notable for a lot of reasons, but just to make it clear, this case was decided in January 2020, and in January 2020, the tribunal decided to grant security for cost. This was a majority decision, and it was strongly criticized by the dissenting arbitrator. However, in 5 months, in June 2020, the claimant proved that he is unable to comply with the security for costs order. And the result of this information, the result of the fact that the claimant is unable to post prescribed security, was that the tribunal decided to revoke his decision to lift the measures. And again, this decision was taken by a majority tribunal that underlines in fact, that this question provoked a lot of discussions, and these heated discussions resulted in two dissenting opinions on the matter. What was the main point why it was so heavily criticized? Well, this makes me move on to excess of justice considerations. So one of the critical points which is discussed within the context of the third-party funding related to a security for costs is access to justice, and how, in fact, security for costs affect the ability of the claimant to pursue its claim. As you might see on the screen, at least some tribunals underscored that it is not a part of the ICSID dispute resolution system. So the system does not require the claimant to have sufficient financial standing, sufficient financial resources to meet a possible costs award. So in fact, it makes sense, because otherwise we can assume that states can easily apply some sort of legal strategies which would help them to avoid responsibility just by making endless application for security for costs. And another point to discuss here is that if the threshold for granting security for costs is lowering over time, then in fact, without any doubt, the cost of financing will rise. And this will be a problem not for big corporations, but for small and medium-sized enterprises who are unable to provide sufficient financial resources to cover a significant adverse cost award at the beginning of the proceedings. So that's basically the reason why the access to justice is something that should be taken into account when we are developing new legal tests for a security for costs. Another point to make is related to the ICSID arbitration rules, the updated version, which was released in 2022. And we understand that this is something that is the UNCITRAL working group is looking at when they proceed with the text of their documents. I assume that they are not coherent for 100% so far, but I believe that the discussions which were a part of the development of the updated version of the rules are helpful to see what concerns states have in respect of the updated rules in respect of the security for costs. So what we can see here is that ICSID refused to put third-party funding as a self-sufficient and standalone ground to grant security for costs. This is, in our opinion, this is a balanced approach which helps to avoid unnecessary complications associated with third-party funding, which is not anyhow related to financial difficulties. So we see that, in fact, paragraph 4 of the rule 53 provides a rule that, in fact, we have to look at the third-party funding in conjunction with the grounds which are listed in paragraph 3. A couple of recent cases which are, in our understanding, a result of the amendments to the ICSID arbitration rules. First case was a ICSID case, and the second one is ICSID additional facility case. Nevertheless, the rules are equal, the wording is the same, so the relevance seems to be equal for our purposes at least. So in first case, this is a clear indication that a number of factors which were discussed in Herceg versus Turkmenistan nowadays will lead to a security for costs. So we can see that the party was relying on a third-party funding, and its beneficial owner was bankrupt. And in fact, the funder was not liable for any costs. So the very prominent tribunal decided to grant the security for costs, and we understand that its case is pending so far. Another case which is notable in this context is Comparative versus Republic of Costa Rica. And what is important here is that this underlines how it may work in practice. So the Costa Rica asked for security for costs, and the tribunal granted the application. This case also involves the third-party funding. So the claimant was unable to comply with the security for cost order, and for that reason, the tribunal decided to suspend proceedings. However, in May 2025, the claimant decided to refile his claim against Costa Rica. So that's possibly something that we will see in the future, because we understand that at least ICSID arbitration rules provide for a lower standard to get security for costs, and I would say this is a matter of strategy. Claimants not always willing to pay this security, and it would be, or it seems to be easier to reinitiate the proceedings against the states and not to proceed with the initial claim, just to abandon it. I would like to stop on the issue of disclosure, which was discussed by Evgeniia so far. And our opinion here is that the disclosure to support the security for cost request is not something that happens rarely, but we understand that it is completely dependent on the position of the tribunal in respect of the grounds for granting security for costs. So let's imagine that you are requesting information about the liability of the funder over the adverse cost awards, and if it, in the opinion of the tribunal, this cannot lead to a this information, even assuming that it is correct and the funder is not liable for costs, if it is in the eyes of the tribunal, should not lead to a security for cost order, then the request for disclosure will be denied. Our understanding here is that the modern rules, including 2022 ICSID arbitration rules, limit mandatory disclosure to the existence of third-party funder and third-party funding itself and the identity of the funder. So the rest of it is supposed to be disclosed by request from the opposing party. And this is a part where we have some sort of a disagreement in our group when we've been working on the draft paper. We've discussed that Evgeniia is supporting the position that a long list of the grounds to disclose information in respect of the third-party funding seems to be not that good from the standpoint of the legal technique. However, I would say that from the practical perspective, we've been witnessing some arbitral awards where the tribunals are referring to discussions which are currently ongoing in ICSID or before the ancestral working group. So that's underscores that, in fact, if this is a part of the draft provisions, then the tribunals might see an indication that the states are willing to have a clear guidance in respect of the disclosure to support the request for security for costs. So mentioning a longer list might be beneficial for the states to support their position. So it wouldn't be a case-by-case basis. So it might be some sort of a indication that on the international level there is some kind of concern emerged. We now see how draft provision 5 evolved over the 1 year. So the version which was analyzed as a part of our research was released roughly in June 2024, and you may see the wording on the screen. So I suggest focusing on the last subparagraph, which is subparagraph E, and another version, which is on the right, was released this summer, and we understand this is a product of work which was ongoing throughout this year. So we understand that the amendments reflect the position of the states in respect of the third-party funding as a ground for security for costs. And now we see more coherence between the draft provision 5 and Article 53 of the ICLRC arbitration rules. So in annotation to draft provision 5, it is clarified that in fact third-party funding is supposed to be assessed in conjunction with the rest of the list from A to D, and it has no separate value in respect of the tribunal's decision on the security for cost. So that was our primary concern when we've been working on the research paper. So we've seen that, in fact, no cases support the position where the third-party funding itself becomes a sole ground to grant security for costs. And we welcome these amendments. We believe this is a more not that extreme approach, which might be, which in fact might be beneficial in the future and might help to underline that third-party funding is important, however, not to make it a exclusive and the standalone ground for such a important decision as security for costs. We now move further to allocation of costs, and I would like to make a few more points in this respect. So first of all, the general question which is supposed to be discussed is whether the funded costs are in fact reimbursable. So we understand that well, the funder is paying for some costs which are required to proceed with the claim. So, well, one of the examples is legal fees of the team, which was retained by the claimant, and we understand that in most of the cases, the lawyers are being paid by the funded party. So, as we analyzed the wording of the applicable arbitration rules, we understand that in most cases it is a matter of whether the party has incurred this cost, and this leads us to a discussion over the nature and the structure of the funding agreement. So if we understand that there is no legally binding agreement which makes the funded party to compensate the funder for their expenses related to the proceedings, then it seems that allocation of costs and reimbursement of costs will result in some kind of unjust enrichment on the side of the on the side of the funded party. Again, cost recovery may be denied in some cases when there is no legal obligations, and we have a separate example in a case of Quasar de Valores versus Russia, which was already mentioned, and we will discuss it further. Another point to discuss is how third-party funding itself affects the allocation of costs at the conclusion of the proceedings, and our answer is that third-party funding is not supposed to affect the allocation of costs, and we are familiar with the body of the case law, which confirms this point of view. All right, are funded costs reimbursable? So that's the question which was discussed in Quasar de Valores case. We understand that this is not a typical case of a third-party funding. So this is some kind of strategic third-party funding, as Evgeniia mentioned. The funder, who is the company Minatep, was a former UCAS shareholder who was pursuing separate legal proceedings under the Energy Charter Treaty, and the interest to contribute to these proceedings was to create some kind of favorable template to proceed with its own claim. So the reason why the Minatep was financing these proceedings was to make a good position, a good precedence in the future for his own case. What we have here is that the tribunal underlined that third-party funding is supposed to be a part of the legally enforceable bargain. So the funds are supposed to be provided under the legally binding agreement, and the funded party is expected to have a legal obligation to compensate the funder for the expenses they've given up to support their proceedings. And in fact, a total free ride deserves no compensation. We have another example. All right, this is about the cost allocation. So in this case, the tribunal refused to compensate the claimants to reimburse the costs which were funded by Minatep, and the reason for that is that the claimants had no legal obligation to compensate these amounts to the funder. And another point to discuss is a cost allocation, and here we rely on the Fuchs versus Georgia award, which was one of the first cases which, well, in fact, faced the situation when the respondent was objecting to a cost recovery due to the fact that the claimants were relying on the third-party funding, and the tribunal acknowledged that it knows of no principle why any such third-party financing agreement should be taken into consideration in determining the amount of recovery by the claimants of their costs. So in principle, the tribunal confirmed that third-party funding alone should not anyhow affect the allocation of costs. And this position was in fact supported by a number of annulment committees, exit annulment committees, for instance, in cases RSM versus Grenada and ATA versus Jordan. So it appears to be a bottom line in questions associated with the cost allocation and third-party funding. And here we have a draft provision 9, which is basically the answer that the UNCITRAL working group have in respect of the costs associated with the proceedings, and the paragraph 3 in the older version and the paragraph 5 in the most recent version. In fact, they contain equal rules, which in fact they do not allow to cover any cost associated with the third-party funding. The question which we have here is whether the wording related to or arising from third-party funding should cover funded costs. Well, we analyzed both English and Russian versions, and if we take a look at Russian version, it seems to be clear that both funded costs and cost of funding itself, like the cost of engaging a third-party funder to see if this case is well worthy to proceed with. They are similarly covered with this rule, and in our opinion, the funded cost, there is no reason to include the funded cost in this provision, just simply because this is, if there is a legal obligation to compensate the funder for the cost incurred, then it seems that the claimants which are relying on third-party funding will be in a worse situation than the ordinary claimants, and we see no particular reasons to do that because, well, in fact, allocation of costs is something that's supposed to have a to become a compensation, to become a reimbursement. So this is the nature of the allocation of costs, and if this provision is interpreted in this particular way, then we are unable to. Well, it seems to be not too good for claimants which are relying on third-party funding. And that's basically concludes our presentation, and we would be happy to take questions from the audience.
Thank you very much for the presentation and for outlining the problems associated with third-party funding in practice of the tribunals. It will be very interesting to see how these problems will be addressed further in the draft provision. It seems to me that while the third-party funding is relevant for access for justice for the funded party, which is the claimant in the proceedings. It has further consequences for the claimant directly in the course of the proceedings, and sometimes stringent, as for instance was discussed with respect to the extensive disclosure requirements. Now we have some time for questions, and as we said, you can send them to the chat, and we have a question. I will read it aloud. Is it possible for a funder to find funders for himself to help him fund a case? So the number of funders will increase to 5 to 10 or even more.
I think it will be a very strange way of doing business for a funder, generally, because we should, I think it's in very business and I think regular funding scheme. We're thinking of companies like Omni Bridgeway or something like that. And what they do is that they don't find funders, they find investors. And how funders work is generally that they assess the case and decide whether the case is rather beneficial for them, or is it possible to win this case, to invest money in it. And so it will be strange if a funder would have a chain of other funders who will each assess the case and or assess a funder, I don't know, to somehow to fund the case. But I think if we are thinking about the chain of funders, not as a funders, but as investors, this is totally reasonable. So yes, I think companies like Omni Bridgeway or something like that, they work with investors and they have money from some sources. They just don't generate it, I think, only through arbitrations.
Well, just to build up on what Evgenia just said, well, it appears to be triggering the question of who is the funder in fact. So let's assume that the funder decided to engage, to approach a bank to have a bank loan and to use this money to solely to fund the proceedings. So do we assume that the bank itself is a funder in this particular case, or should we just look at the nominal company, the one that it appears to be concluding the agreement with the claimant?
Thank you very much. We also have another question. You most likely have identified through your research some questions that were not included in your paper due to format limitation, etc., but still deserve further exploration on the topic of the third-party funding as part of the ongoing ISDS reform. Could you please share with us these topics so that those who might also want to do some research on this topic could reflect on them as well?
I
Can
assume
I start?
Oh,
You
yeah. Please go ahead. Yeah.
Thank you very much. I'm talking firstly today, all the time. But so I think one of the interesting topics that I would like to explore more is whether it's actually like theoretically possible in investment arbitration to extend jurisdiction of a tribunal to the funder, because I think it would solve a lot of questions that we have today. And because in many in some, not many, but in some jurisdictions, it is possible to join the funder in the end of the proceedings and ask for some money or something like, for example, under the UK legal procedure, it's in England and Wales, it's possible. So in investment arbitration, it's not possible due to the current BITs and how the jurisdiction is decided. But I think today a lot of arbitrators try to kind of fairize and think about this. Like, for example, in one of the recent cases in Silver Bull Resources versus United Mexican States versus Mexico, this was also fairized about whether it's possible or not. So, yeah, I think it's an interesting point.
And I believe we have another topic that we've been discussing throughout the year when we've been working on the research paper. However, we decided not to include any indication that we've discussed it to the text. Well, this was related to sanctions, and our discussion was focusing on the fact that sometimes disclosure is required to see if the fund is complying with the sanctions. So it might go well to beneficial ownership or the source of funds. So, our opinion was that the sanctions, well, let's say US sanctions or EU sanctions or UK sanctions are not a part of the international legal order. So that's apparently why the UNCITRAL is not discussing any kind of such ideas under the auspices of the United Nations. However, we understand that from the practical perspective, it might be something that is a part of the environment today. So our understanding is that it might be reasonable to see if this is to make it. To make it clear, we have identified one case in the United Kingdom when the funder was was evading sanctions just by way of providing money to support the proceedings. So that was the reason why we decided to see if it works for the international investment arbitration. However, well, that's never materialized in any text.
Yeah, it's not, and it's not actually only sanctions. It's also any kind of like great source of funding, like money laundering or any other problematic funding. So, but yeah, resources about that are really limited.
Thank you very much. They seem like very interesting questions, and I hope that they will be developed in the papers of the participants of our webinar. Perhaps a last question. How do you assess the impact that the draft provision on the third-party funding in its current form may have on the practice of the third-party funding? Would it streamline and set out best practices, or rather would limit the third-party funding?
I think it's a very difficult question to answer when you are not a third-party funder. Because when I talked with third-party funders and I had an ability to talk with some representatives, some companies, they said that, but it was about the old draft, so not a new draft. So they said that they actually like welcome the disclosure, and they always for disclosure, and they provide full disclosure every time on every case. I don't know if it's like true or not. And I don't know how like we really feel about the disclosure obligations, but we can see that even in a lot of arbitration rules today, in a lot of big arbitral institutions, that there are already disclosure requirements. And I think that at least in draft provision 12 that we analyzed with Anton, it would kind of set, I think, some ground rules or guidelines how everyone should work, and not how some arbitral institutions should work and some like should avoid such rules. So it will be some kind of a like guideline practice. But at the same time, what we can see today is that the new draft article, because if you can, we analyze disclosure mostly, but if you open the new articles, there is draft provision 12 bis, there is a regulation of third-party funding, and they try to limit third-party funding. And I wouldn't go into much details about it because I have not analyzed in detail or write a paper about it. But I think if something like this we will see in practice, that would limit the third-party funding because it's aimed at limiting third-party funding. So obviously we'll have something trend something like that.
Just to follow up shortly, well, we hope that at least, well, the question which was analyzed for this year was how to make it possible to use a third-party funding, which is essentially a private law construction. So you base your arrangements on the contract. How to make it live together with sit well together with the investment arbitration, which is at least at some point became more and more transparent. So I believe that the amendments which we are facing right now, meaning the draft provisions on procedural and cross-cutting issues, will hopefully bring some transparency into the world of third-party funding. So it will become a matter of publicly available information, or at least for the purposes of the proceedings, it will become more open to the parties of the proceedings.
Thank you very much. It will be very interesting to see the impact of new proposals in the future and how the practice will respond to the amendments. I think with this, I would like to thank you all, Anton and Evgeniia, for presenting your thoughts today, and also the participants of our webinar. I invite you all to follow closely the ISDS reform and also the activities of the Investment Law and Arbitration Lab. Thank you very much.
Thank you. Thank you everyone for listening our endless thoughts about third-party funding today, which may be boring, I understand.
Thank you.